Good afternoon. The final session of the symposium is called Looking Ahead. Just before lunch, we started looking ahead by considering a pilot study to reintroduce a species in Banff National Park that was nearly hunted to extinction. And this is after 140 years that the species has been absent from the park. Then we looked to the future in the context of co-management regimes that enforce laws to protect much of the remaining Canadian wildlife located in northern Canada. And thirdly, we learned about the value of a traditional land use study, cultural awareness, and cultural monitoring to protect grizzly bears. The panelists for this afternoon session have already been introduced to us. They will include Martin Olinsky, our first presenter, Philip Saunders, and Alistair Lucas. Now, continuing to look ahead, this afternoon we will consider the proposed changes to the Federal Fisheries Act and the Federal Impact Assessment process, and the implications of the proposed changes for enforcement of laws to protect wildlife. As you're all aware, the Fisheries Act has played a very important role in protecting Canadian wildlife. And now Martin will provide his insights into the proposed changes to the Act that may facilitate increased wildlife protection. Professor Olinsky.
All right, well, good afternoon, everyone, and thanks for hanging on to the afternoon. Hopefully it will be worth it. So I'm going to spend about 15 to 20 minutes talking about the Fisheries Act mostly. I think, for sure the Impact Assessment Act is relevant, and we can spend some time maybe during question and answer period talking a bit about that. But I think in terms of what, the theme of this specific symposium, I think the Fisheries Act for sure deserves some consideration. And I think it's safe to say, for the past 20 years or so, I think for the general view was that the Fisheries Act and its prohibition, especially against impacts to fish and fish habitat, was probably the most powerful federal environmental law that we had, and at least on paper, right? And so there were always concerns about its implementation, in fact, and on the ground, but on paper it was a very strong, certainly a very strong piece of legislation. And what I think I'm prepared to say, having looked at it now for a while and having thought about the amendments that are being proposed by the current federal government, is that it will return to that place. And in fact, we can actually also anticipate that it will be probably more effective than it ever has been, okay? And so in terms of the next 15, 20 minutes, what we'll do is I want to give a bit of the backstory for those of you. Some of us have been following this process, which has been really 2 years in the making so far, very carefully. I do want to provide a bit of that context for those of you who maybe haven't. And then I'm going to jump into what I consider to be sort of the big changes that are going to be brought into place into the Fisheries Act. So in terms of, and then if, depending on the time, we will spend some time talking about the Impact Assessment Act as well. So all of this began just over 2 years ago now, right? In the fall of 2015, we had our last federal election. And at that time, the Liberal government, the then not yet to be, soon to be Liberal government, made it a fairly prominent plank in their campaign that they were going to restore the protections that were lost by the previous Conservative government in 2012. Okay, so some of you may remember that in 2012, under the Harper government, there was two omnibus budget bills introduced, and they essentially brought some fairly significant changes to the federal environmental regime that included not just the Fisheries Act, but the Canadian Environmental Assessment Act. What was then called the Navigable Waters Protection Act was renamed the Navigation Protection Act, and its scope was reduced. And I think that that's a fairly accurate description of the general thrust of those omnibus budget bills in 2012. It was to reduce the footprint, shrink the scope of the federal environmental regime. And that certainly happened on the side of the Fisheries Act, where the attempt was to take what was previously, or at that time anyways, a broad prohibition against impacts to fish and fish habitat, all fish habitat in Canada, to only impacts that had, and only fish that were a part of or supported what the government described as a commercial, recreational, or aboriginal fishery. And we changed the level of the harm from a broad prohibition against harmful alteration, disruption, and destruction, so it didn't have to be permanent, it could be temporary, to a narrower set of what was described as permanent alteration or destruction, okay? And so we had this, we've had a series of initiatives, parliamentary committees with respect to the Fisheries Act changes and with respect to the changes to the Navigation Protection Act. We had the Standing Committee of Fisheries and Oceans undergo a review, and the Standing Committee on Communities, Transportation and Infrastructure review the Navigation Protection Act. We had an expert panel called together, which brought together some of the long-time experts in Canadian environmental assessment law. And they traveled, notwithstanding the fact that their mandate seemed actually maybe a little bit narrow on paper, I think they did everything that was humanly possible, and maybe even more than humanly possible, to travel Canada and meet, and they met with hundreds of witnesses. They heard from multiple groups. They traveled north, they traveled east and west, and put together a very ambitious report, Building Common Ground, and that's available on their website to this day. There was also an expert panel on NEB modernization, right? So the other part of this was changes to Canada's energy legislation at the federal level. So those parliamentary committees and those panels did their work. They reported, they submitted reports which are broadly, publicly available online, and the government replied to those reports in 2017, in the summer of 2017, with a discussion paper which provided a fairly high-level overview of where they were going to go with that with those reports, what they thought of those reports. And I think it's safe to say that, not all reports were treated equally. I think that, for instance, the Fisheries Act work was, fairly well accepted within the government. Some of the more bold recommendations that came out of the expert panel on environmental assessment did not see the light of day, or were not reflected in the government's discussion paper. And we'll talk a bit about that depending on how much time we have. And then, of course, most recently in February of this year, the government tabled Bill C-68 and Bill C-69. 68 is essentially amendments to the Fisheries Act, and C-69 includes the Impact Assessment Act, a new Canada Energy Regulator Act, and changes to the navigable, what will now become, so we had the Navigable Waters Protection Act, then we had the Navigation Protection Act, and now we'll have the Canada Navigable Waters Act. So in terms of the Fisheries Act, again, for those of us, to get a better sense of where things are going. So these were essentially the recommendations that came out of the Standing Committee on Fisheries and Oceans, okay? So the clearest, the cornerstone that everybody was waiting for, I think, and hoping for, and maybe not everybody, but the vast majority of stakeholders, was a return to the broad prohibition against harmful alteration, disruption, or destruction, and excision of the serious, the stuff that I described before, this idea of fisheries and the idea of a higher level of harm, so having that excised out of the Act. Some more clarity around what constitutes there was clearly at the committee level, there was concern raised by certain sectors, municipal, agricultural sectors, saying, we don't want to necessarily go back to the, we accept that the 2012 changes are a mess, basically, but we don't necessarily want to go back to the previous regime because that also gave us some trouble. And so there's a committee, you could see the committee trying to reflect that by saying, we understand that we need to provide certainty and clarity to these sectors. Increased resources, okay, so there was, and we're seeing that generally, there is more money being put into the system. And then an online registry and database was another thing that became clear, the idea of transparency in the fisheries management and habitat protection, that there had to be a way for Canadians to sort of be able to assess themselves how the department is doing. And so we saw most of that reflected in the government's discussion paper, okay? So this is, and I've got excerpts, and I apologize, not really for your reading. It's just to show you that I did some preparation coming into this. And so we've got partnering with Indigenous peoples was obviously an important aspect, and I think everyone, that's one thing that stands out in this package of legislation that was tabled in early February is the imprint of Indigenous peoples, and recognizing Indigenous peoples' jurisdiction in the resource management, I think, is definitely a prominent feature. There was some discussion about planning and integrated management, partnering and collaboration, okay, and reporting back to Canadians. So again, reflecting that committee recommendation of transparency, of some kind of public registry. So we saw the government's discussion paper embracing that and talking about reporting, improved reporting from proponents, strengthened compliance monitoring, and timely, relevant, and accessible information. And so we're going to see all of that in the legislation. So for those of us who were following all of this, you know, when we got our hands on the bill and everybody was paying attention and waiting, and then you cracked open that first page, and you very quickly came upon this clause, and I imagine that there was like a collective sigh of relief, I guess, I think, in the universe or something like that, where everybody was like, okay, good. And this signaled very clearly that the serious harm to fish regime, with its attempt to try to restrict the scope of the act, that this was going into the dustbin of history. And so I think that was a positive note to get into, and that story that positive story, I think, generally follows through as you read the Fisheries Act. And you know, and again, I mentioned that there are really 4 pieces of legislation that are being amended here, and I think the general view is that the Fisheries Act is the best story out of all of them. There are some good things in some of the other acts for sure, but the Fisheries Act is pretty clearly, and it's not to say it's perfect, there are some problems still with it, but there are definitely some really good things. And so starting off with just new definitions, and I talked about the need for clarity, right? So one of the questions always was, well, what is fish habitat? And so the Act's been amended. Previously, fish habitat was essentially tied to the life processes of fish. So it was an area where fish spawned or where they were feeding or whatever. This new legislation will just very clearly, fish habitat is where there are fish. And that makes sense, okay? And that's it, so full stop. So we don't have to, you know, no more sort of fighting about what is or what isn't fish habitat. Fish habitat is where there are fish. The definition of fishery, because it still is relevant, of course, to the legislation, that's been amended to make clear that when we're talking about a fishery, you don't actually have to prove that there's some actual fishing going on. Rather, it's whether the fish are fished or not, right? So we speak about a fishery in terms of the species. You might say that there's a walleye fishery in the province of Saskatchewan, or here in Alberta on the Bow, there's a trout fishery. And that's whether you fish in a specific reach of the river or not, right? We know that these are all part of a fishery. And then probably, again, going back to this point about Indigenous peoples and recognizing Indigenous jurisdiction, the definition of Indigenous governing body, right, was introduced. And we see that that is incorporated later on to into Section 4 of the Act, which allows the government to enter into agreements. The department can enter into agreements with other levels of government, and before this legislation, those other levels were restricted to provinces and territories for the purpose of implementing the Act. So the Act now has been amended to include, alongside provinces and alongside territories, Indigenous governing bodies. And I think that, of course, we'll have to see how this all rolls out, but I think that is a pretty powerful recognition that Indigenous peoples do have jurisdiction in this context and that it should be recognized. There's going to be a new purpose clause in the Act. So the Fisheries Act actually is a bit of an oddity. Most laws in Canada will have a purpose clause, which is intended to really sort of help courts in their interpretation of the Act. The Fisheries Act had one at an early time in the 80s, but then it lost it. It is essentially being reintroduced. And on this point, I guess I would say I would caution anyone from getting too excited. I mean, I think at the end of the day, this has essentially been, by virtue of the case law, this has been understood by the court as the purpose of the Act, right? That the minister manages and controls the fisheries in the public interest, okay? And so we have several sort of cases saying that in the context of at the Supreme Court, and I think that still is more or less the case right now. I don't see this as radically changing anything, but I do think at the same time it does send a good signal that this is really what the Act's about. It won't prevent, I don't think, DFO from engaging in things that are bad for fish and fish habitat. I mean, that's part of the cost-benefit analysis that the department's going to have to take on a case-by-case basis. Alongside, again, furthering that idea of recognition, we have clear now Section 2.3 and 2.4, recognizing the rights of Indigenous peoples in Canada. and really codifying the case law, and especially the constitutional Section 35 duty to consult case law, right? That the minister shall consider any adverse effects that his or her decisions under the Act may have on Section 35 rights. Well, so that of course that's always been the understanding, or at least since HIDA in 2004. But again, I think that there is some value in these laws, these natural resource and wildlife laws, recognizing that relationship between Indigenous rights and decision-making by government. There's a new considerations clause. So one of the things that we didn't have a lot of in the Fisheries Act is any kind of sense of, well, what is it that the minister may consider when he or she is making decisions under the Act? And so we have a couple provisions now, and then this trend did start, I have to admit, in 2012. So for all the bad that 2012 brought, and there was a lot of bad, it had introduced for the first time this idea of factors that the minister had to consider when he or she were making decisions with respect to habitat. What we see in the legislation brought forward earlier this month is this idea that being more transparent about what is at play, what we're going to consider, is a good thing, and this applies broadly now throughout the Act. The problem, if there is one, of course, is that it is still very discretionary. And we were on social media having some conversations about the Fisheries Act, and a colleague here in Alberta pointed out that anytime you read the word may, you can read it as may not. And think about what that means for the legislation in that context. And so, for instance, we do know that coming out of this, the minister may not consider scientific information, or the minister may not consider the sustainability of fisheries when they're making their decisions, or they may not, think about the application of the precautionary approach. And so this is, when you frame it that way, you realize that maybe there are some things on this list. I understand that not all factors are going to be relevant in all cases, and we want to be mindful that there is going to be some discretion here, but maybe that some of these factors could be moved into a mandatory sort of list. Just like actually we'll see when we talk about the registry provisions, there's mandatory registry provisions, and then there are sort of discretionary optional ones. And so similarly, maybe some of this list, I think I think it's not crazy to say that the minister should always consider scientific information. And traditional knowledge, for instance, so long as it's available. And remembering, of course, always that this is not binding in any way. All we're saying is that you consider the information before you make a decision. It doesn't say that the information will determine the result or anything like that. In terms of Section 35, okay, so I mentioned, I think earlier, the big change here is a return to the previous prohibition against harmful. So now it's going to be any work, undertaking, or activity, which in your mind, you might just think to yourself, projects, essentially. It's a little broader than that because it has that term activity, that are likely to result in harmful alteration, disruption, or destruction. So these are all going to be are now prohibited. But of course, the minister has retained the ability to authorize these impacts, okay? And here it seems like the government essentially envisions three types of projects on a go-forward basis, whereas before it was just kind of like anyone and everyone who was concerned. And we've done some research, and we know that, for instance, like in a given year back in 2002, the department would get something like 12,000 referrals in a year. People asking, do I need an authorization? How does this work? Okay, and so they did a bunch of triage, and part of the story of the Fisheries Act for the past 15 years is that triage process and whether or not it was sufficiently transparent. And so it looks like what the government has done is said, okay, fine, fair enough. We know that there's going to be smaller works that we are not going to subject to a full authorization process. On the other hand, there are going to be other works that we will always subject to an authorization regime, and we don't want to engage in the jockeying that we used to engage in, that used to burn so much time and effort and money between the department and proponents. Do you need an authorization? How can you avoid an authorization, and all this kind of stuff? So what they've decided, I think, is that there are going to be three types of projects. There are minor type projects, which will be generally subject to guidelines and codes of practice. Okay, so these are things that we think, generally speaking, if you follow these codes of practice, you can avoid impacts. On the other far end of the spectrum, there are going to be major projects, and the department's going to create a regulation and say, you're going to need an authorization, full stop. We don't want you to come and horseplay with us or anything like that and try to negotiate out of this. There's a designated project list, and if your project is on that list, you're going to need an authorization. And then in between are the medium projects, where the department will engage in some discussion because maybe an authorization is not required, and in which case they propose to rely on somewhat contentious or very contentious practice of issuing what they call letters of advice, or else they will tell the proponent, yes, go ahead, you need an authorization, and they'll bring them into that regulatory stream. Whenever the minister is issuing those authorizations, they now have a list, an expanded list of mandatory considerations. Okay, so in this case, in the context of authorizations, we displace that previous section of considerations that I mentioned, and instead we have this list, and it is not discretionary. And I've italicized the new factors. So some of this was already present following the 2012 changes, the idea of contributions to the productivity and fisheries management objectives and all that kind of stuff. What's new and what's, I think, important and I think very positive, a clear requirement to consider the cumulative effects of these projects and of these authorizations with a view to other projects on the landscape, right? So this idea of recognizing that individual projects may not break a watershed, but when you have hundreds of them, you may be getting into problems. And so the department now has a clear obligation to do this, and I think that that's positive. There's also reference to habitat banking, and I'll talk about habitats in a bit. That's also a new thing, so this idea that instead of having each proponent offset or compensate for their impacts to fish habitat, they may have access to a bank of offsets and projects which they can essentially purchase credits from. So that's all now there in there. Traditional knowledge is a mandatory consideration. Again, that wasn't the case before. And so all of this now is mandatory. And the other big part here, of course, is that because before we had some mandatory considerations as well, but it was sort of like, well, so what? Because no one knew, except for the proponent, except for the person that receives an authorization, there was no way of knowing what the minister, how he or she considered these factors, because there's no registry, there's no transparency. It was very hard. The only way for a member of the public or an academic or an interested group to have access to these authorizations was to file an access to information request. And so now the idea is that these will all be on this registry, and we will be able to assess how the department is dealing with these issues by viewing these authorizations and scrutinizing them that way. So just a quick couple of words about habitat banking and the registry, and then I think I'm happy to open allow one of the next speakers. How am I doing for time? Fine? Okay. So habitat banking. So, I mean, and we have actually an expert here with us, Dave Polton, and he can answer probably more questions about this than I can. But, I mean, I think that, again, the basic idea here is that instead of having proponents hire and engage in piecemeal habitat compensation work or offset work, there will be third parties who will engage almost on a commercial basis. They will engage in the activity of habitat restoration that can be more carefully designed and more purposefully planned, and then they will sell those essentially chunks of that so that a future proponent comes up, and if they've offset, let's say, 2,000 meters square of habitat, and I'm a proponent and I'm about to have an impact on 500, well, instead of me rebuilding 500, on a piecemeal sort of basis without a lot of expertise and having to hire somebody to do that work, which is inefficient, I'll just purchase 500 meters from that bank, okay? And all of this will be on the registry, so these banks will be on the registry. There'll be a way to sort of assess how they're performing. And again, I think that there's an opportunity here for more thoughtful and efficient habitat offsetting. There is, of course, lots of literature saying that this is a bit of a fool's game and that man-made human habitat is never really as functional as natural habitat. And there's something to that, and that's why traditionally we require like a 2-to-1 ratio in this context. I think it's a best practice is to say, so for every 1 meter, you will compensate or offset 2 meters to take into account that fact that manufactured habitat is not as effective. So some of that is going to be about making sure that these provisions are going to encourage a sort of the best habitat banking. And we have experience that we can look to the south in the United States. They have quite a bit of experience with habitat banking. So hopefully we'll be able to learn from that and really drive this and have a world-class habitat banking system. And so then, the last thing I just want to discuss on this point is the public registry. So this is, so we have lots of registries at the federal level. We have a registry for the Canadian Environmental Assessment Act for projects under SIA, which will soon be the Impact Assessment Act. There's a registry under SARA. There's a Species at Risk registry. And so this will be a similar thing, I envision, an online registry where there will be, depending on what you're looking for, you will be able to get access to issued authorizations, Ideally, I think it would be good to also have access to monitoring data that proponents have to submit as terms and conditions of their authorizations. And so we'll be able to sort of say, okay, so how is this going? How is this looking? Because we have done some work, again, using ATIP, myself and Brett Favreau, who's at Memorial University. We took 87 authorizations from 2012, and we looked at the number of meters squared of fish habitat impacted versus the amount required in terms of compensation. And lo and behold, there was like a 3 million meter squared gap. Okay, so notwithstanding the department's promise of no net loss or its policy of no net loss, we found that actually based on just these 82 or 87 authorizations, there was 3 million square meters of habitat being impacted that was not being compensated for. So this is the kind of stuff that hopefully the registry will be able to bring out a little bit more clearly and will encourage the department to really tighten up its authorization regime to ensure that we are not losing fish habitat in Canada. So there are some things that we could still fix. Like I said, overall, pretty good news story. Some of the things that I think people will be looking for. One thing that's not in the Act is any kind of commitment in a legislative sense to report on the state of fish habitat in Canada. So again, that's something that since 1986, the department has had a policy of no net loss, of net gain, in fact, fish habitat. And yet any time that someone has asked the department, how's that going, by the way? The answer has been like, well, actually, we have no idea. So I think it would be useful for the legislation to contain an explicit commitment to reporting on the state of fish habitat, even to essentially amalgamate, like just do straight up just addition. Review all of your authorizations on an annual basis, see how much habitat you authorized impact for and how much you required compensation for, and then tie into that maybe some reporting and monitoring and tell us how that's going. So I think that's something that has to go in. There's also a bit of concern with respect to those small projects, standards, codes of practice, and that kind of thing. It's not clear that that information will be like that the proponents of those projects will provide that information to the department. From a cumulative effects perspective, it would be really cool if they did, because of course those projects might seem innocuous, and they might individually seem minor, but again, if there are hundreds of these kinds of projects on the watershed, you need to know about them if you really are serious about managing cumulative effects. So I suspect that part of the problem here is this fear that if the project's not having actual impacts on fish habitat, that the department feels like it has no business requiring anything from anyone. And some of that is based on maybe an interpretation of sort of 1980s Supreme Court jurisprudence with respect to the Fisheries Act, and I get that, but I think that jurisprudence needs to be read in context, and it needs to be read also with a view to common sort of modern environmental law principles, which are, of course, that environmental law is preventative and anticipatory, and it can't be the case that you have no ability to require notification about a project that may impact fish habitat until it's actually done it, so that's going to be a conversation that we're going to have. But like I said, overall, I think a really positive story, and I think the Fisheries Act will return to its place as a strong, as Canada's strongest sort of environmental law on the ground in terms of protecting wildlife, in this case fish, of course, and their habitat. I feel like I could probably just end there.
So at this stage, I would like to invite Professor Saunders, Professor Lucas to come up, and Professor Linsky, and we can delve into the Fisheries Act in more detail, take some questions, have a discussion of these before we take a look at the Impact Assessment Act. So, do we have any questions from the audience in terms of the proposed changes to the Fisheries Act? Yes, and we'll just move the microphone over to. Thank you, Nancy.
I agree.
The section there on habitat banking,
I'm interested in hearing a little bit more about that. Over the years, there's been we've had tree planting exercises that have been becoming more common. Problem with that is typically they focus more on the replanting the merchantable timber rather than the other species, which actually do provide an environmental and wildlife function. So I'm just wondering if there's what the plan is, or if there's a more concrete plan around that habitat banking, or what kind of science went into proposing that.
So the current provisions are pretty open at this stage. They don't get to that level of specificity. Really, it's about enabling the idea even of habitat banking. There is some framework, some machinery. So the idea, for instance, that a habitat bank will be in a designated service area. And this goes back to the idea of sort of when we compensate or offset, and I'm watching Dave's face to make sure if I say anything wrong, he'll tell me. Good. This idea of like for like. So if there's a certain kind of impact that you're a certain kind of fish habitat that you're going to be impacting, altering, destroying, or whatever, then the general presumption is that you should replace the same kind of habitat. So if it's riverine, it'll be riverine. If it's lake, you'll go ahead and do lake work. So that, again, but at this high level, in terms of the machinery here, it's really just about enabling. And then I think the other point is that, at least my view, and so what I've sort of seen from some of the other committee witnesses, like the Canada Wildlife Federation, there are lots of places in the watershed where habitat's been degraded, and it could use just restoration. And you might think about, and it's one of my sort of like go-tos is the idea of a perch culvert or of a poorly placed culvert. And so I think the idea is that if you go ahead and you do that work as well, that then becomes potentially creditable conservation offsetting work that then someone can purchase a credit for.
That may be, for example, if you have habitat that's been impacted by invasive aquatic invasives. I think there's some science that's going on in terms of rehabilitating or restoring wildlife habitats. I think that's University of Waterloo. But I don't know that there's a lot of traditional knowledge being incorporated into that type of methodology. But I think that generally, if you have a more biodiverse network, you're going to have more resistance to those kind of impacts to wetlands and other areas.
Yes. Yes.
Hi. I don't know anything about law, but I don't know if this is the right time to ask this question. But I heard a long time ago about a Prosperity Act, and it seems like it's called Jobs, Growth, and Long Prosperity Act. I don't know. Is there any relationship here with that act at all, or not?
Yeah, I mean, it's basically about undoing correcting the parts of the Prosperity Act which were maybe not necessarily really geared fundamentally about prosperity. So yeah, I mean, that legislation contained changes to the Fisheries Act, impact assessment, and navigation. And so this suite of laws will essentially undo the changes that those laws brought in. Yeah.
Other questions? Yes.
Under the current fisheries regime, I don't believe there's any statutory home for the initiatives that are being taken in a number of places to establish fisheries guardian programs. And I'm just wondering, I confess that I haven't read all of C-68, whether in fact there's been, there's certainly been funding allocated by the current government to try to support some of those programs, but I'm wondering whether there's been any initiative taken to sort of provide a statutory home or authority for those sorts of initiatives, I think, which are quite important to the kind of monitoring programs that Bill was talking about earlier.
I mean, so there are still provisions for fishery guardians under the Act. I'm just like looking at my former colleague. Yes, yeah. So I mean, those are still there. I think that for the kind of thing that was being discussed earlier, I do think that this Section 4 agreements is going to be broader in scope and allow, because the guardian, I think, is still limited fairly conceptually to enforcement, whereas I think the idea of ongoing monitoring and having some kind of creative community monitoring programs, I think that's something under a Section 4 agreement that might be a little bit more. And so again, that's been opened up. I do want to say also, with a nod to this morning's conversation about AMPS, the other thing that I think is missing from the Fisheries Act, actually from this round, is provisions for administrative monetary penalties. Because at the end of the day, and there's something in there, there's what's called alternative, what are they called? Alternative measures agreements. I think, they're alternative measures agreements, which are a form of sort of restorative justice kind of approach, but I think something that the Fisheries Act could really benefit from. If you think about the kinds of offenses that we're dealing with in the context of the Fisheries Act, yeah, sometimes they're massive, and Erin yesterday, when she was speaking about the Odbin mountain mine spill, obviously that's a significant incident that requires and deserves putting forth the machinery of prosecution. But I think in a lot of cases they're not going to be actually that big, and it'd be awesome if if a DFO officer could just slap somebody with a fine in that context and sort of say, okay, just pay up your $400 or $500 and don't do this again.
Any other questions? Professor Saunders, in terms of your extensive experience in terms of the offshore, is there anything that you might like to add, or in terms of?
Yeah, a couple of things, if I could. And I wonder, would it be appropriate here, because I think there's a looming enforcement challenge. I just might say a couple of things about in the new MPA provisions that the government is also moving on in Bill 58, is it, I think? And I think there's a relation across, but on Martin's treatment of the Fisheries Act, I have a couple of things. I agree completely on the habitat. It's nice if I have to teach environmental law again. I know I can get my old notes out. They'll be relevant again, which is nice to know. But I agree with your analysis of it. It's a nice summary. I would maybe add on the other parts that they tried to deal with, which I think in some senses was a similar approach, and that is the fishing industry. The Fisheries Act is not just about environmental protection. You could argue that happened by constitutional accident along the way, but it is very much about fisheries management in all of its contexts. And there also, I was involved in some of the submissions on that side of things, and one of the elements that independent small-scale fishers on the East Coast, where there are still preferences for owner-operator fleets and the rest of it, which did not survive elsewhere, they really wanted to see further protection of that in the
So I just put the word
okay,
in. Yeah.
in the I'm afraid it was a nasty picture of me or something. So, in the considerations that the minister can take into account, and also in one of the two paragraphs in the purpose section were directly targeted to reinforcing what you properly indicated had already been the case, I think, under cases like Ward and Comeau. That is, I made the mistake in dealing with the press of ending my comments by saying it doesn't change anything. I meant that in a positive way, that the minister already had the power to do all of this. Of course, that's the part they fixed on for the quote, that to make it sound like it was useless. But in the fishing side of things, they wanted more protection for the notion that a minister can validly take into account social, cultural, and economic. The indigenous was already clear, and that was being brought in. But the notion that community impacts and fisheries, particularly on the East Coast, and policies like owner-operator and fleet separation, which are geared to social purposes, really, and to location of benefits, would be protected. It was the belief of the organizations involved that they already were, and there's been a successful outcome of a challenge that other parts of the fish processing industry lodged against those sorts of policies recently in the federal court, but that they have appealed that to the Court of Appeal. We'll see what happens. I don't see it going any differently. But notwithstanding that, the feeling was that if these were reinforced in the Act, it would give some greater strength and in the ability of the department and groups that supported the department's activities in this regard to act in that way with those sorts of policies. And this minister was the first minister for many years who really engaged in full-throated support of things like owner-operator and fleet separation policies to protect inshore fisheries. Not surprisingly, in a way, in that it was his father who first introduced them many years ago, and what was then a bold move, and it's come back around now. So I'd add that bit, but the purpose, I think, the idea, it's already legally justified, but it needs some reinforcement. It helps in preventing challenges. I think your analysis is right. The other thing that was subject to quite a bit of lobbying in the lead up to the legislation was, again, on the fishery side, was an attempt by some NGOs in particular to push more for mandatory responses in cases of declining fisheries. That we don't really have a system in Canada of telling the minister, you must do such and such. The Americans have a much more rigid approach to telling the executive what to do and when to do it under the Magnuson Act and other legislation. And they were trying to get into the Act something that would require a minister, absolutely require them to engage in rebuilding efforts for fisheries that had been identified as falling below a certain precautionary point in the definition of precautionary reference points. They didn't get that. I didn't think they would in our legislative drafting approach. What they got is what is 6.1 in the Act is if the minister's of the opinion that a fish stock has declined to its limit reference point, which is sort of the low end, or is below that point, that it would be impacted, they shall take into account. So there's two measures, rebuilding measures, and other things. So there's two triggers that have to be passed. The minister has to be of the opinion that the stock has declined to that degree, and then they only have to take it into account that maybe you should look at rebuilding measures. So like the other parts, you're not going to get the whole thing. I tried to explain to some of the groups that in the U.S. you have a legislature that's constantly trying to prevent the executive from doing anything but what you exactly want them to do, so they put that in the legislation, whereas in our system, the people drafting the legislation are the people that would be controlled by that kind of mandatory provision, so you're less likely to see it. Those are my main comments on the fishery side. Results are similar. They were positive. A little bit different than in the environmental protection part. Is it okay to mention the MPA thing at this point?
Absolutely.
Get that out of the way. This is something that in another act, C-58, there is a set of revisions to the, C-55, sorry, to the provisions for designated marine protected areas in Canada. So we're into saltwater and the targets around marine protected areas. The reason I mention this is because I think from an enforcement point of view, what you're going to have to enforce in the future is a large part of assessing the enforcement resources you're going to need. And marine protected areas and area-based conservation measures generally are all the thing in the marine sector, trying to move towards new ways of establishing those, even in areas where traditionally we didn't, such as the offshore. Canada's had, since the Oceans Act in the 90s, the marine protected area provisions. We also have a number of other acts that provide for such area-based protections. And when we adopted the Aichi targets of 2011 out of the Convention on Biological Diversity strategic plan, Canada has committed to, by 2020, reaching 10% of its marine and coastal areas to be conserved through ecologically representative systems of protected areas and other effective area-based conservation measures. We adopted the target of 5% by 2017, have supposedly met that, and are going to 10% by 2020. Now, consistent with the CBD these don't have to just be MPAs, marine protected areas. They can also be things like national marine conservation areas, national wildlife areas if they have a marine component, migratory bird sanctuaries, national parks that have a marine element, and what they call OEA BCMs, the other effective area-based conservation measures, which apparently includes any fisheries closure areas, and marine refuges, which is another term that's used under the policy. We managed to get to 5% in 2017 by using all of those. That's how they got it to 5%. There aren't that many marine protected areas per se, actual marine protected areas. But under this new legislation, the essential change is that what used to require regulations by the Governor and Council to create a new MPA under the Oceans Act can now be done, which was a fairly long and cumbersome process, can now be done in a two-step process. The first step being the designation of an interim protection MPA by order of the minister, and second, a later development of the regulations by Governor and Council after consultation, study, etc. And I won't go into great detail on this except to point out a few things that I think are going to create some real implementation and enforcement challenges. First, this bill is just coming through, and we're going to go from 5% to 10% of our marine coastal areas, so doubling it, after taking out all the easy, low-hanging fruit of all the ones that already existed and counting them. We're supposedly going to do this in a few years, fairly quickly. I don't think the department has the staff or the capability to do that many marine protected areas or equivalents, even on an interim basis, with any kind of analysis over a 2-year period. I just don't think it could happen. I think it'd be chaos. I have seen maps that would indicate whole sections of the coast covered by little dots that are going to be these things. I don't know how they've been chosen yet. Second, the Act provides that if you list activities that are ongoing in an area, that is, they've been taking place legally somehow or other over the last year, though the department can decide whether they can take place or not, so they could create non-ongoing activities, that if the activity has not been ongoing in the area, the only choice for the interim protection order is that the minister shall prohibit any of those activities going on in the area, which seems to be mandatory. It's very broad in its impact, and it doesn't give the choice that you usually have in MPAs of doing some regulation of the activity. It is a shall prohibit. The minister may prohibit any activity that has been ongoing in this new designated area. And that seems fairly straightforward. And they can exempt, oddly enough, they can exempt any activity by a foreign national, an entity incorporated or formed by or under the laws of a country other than Canada, a foreign ship, or a foreign state. They could be exempted. And that's because of the problems we have with the amount of jurisdiction we do or don't have over shipping. So I think that's going to be an interesting period of enforcement. If you create that many of these things over the next 2 years, they have to be enforced. Somebody has to be out there to govern the prohibition of a whole range of activities in these new areas. And there's one last drafting problem that maybe it'll be dealt with at some point. These are intended to be interim, so the minister has an obligation within 5 years to bring forward regulations and propose them to cabinet. But they don't have to get them accepted. And there's no provision for terminating the interim order if the minister simply proposes a set of regulations to the cabinet and the cabinet doesn't accept it or doesn't act on it. I don't know what happens then. It looks like it would sort of continue. So that's going to be an interesting one, happening very quickly. The implementation is going to be very challenging, to say the least. And the enforcement of these things at the scale of geographic areas that they're talking about is going to be massive. I don't know where the resources will come from up against all the other challenges that already exist. So just thought I'd add that to the mix.
Thank you, Professor Saunders. Any questions about what Professor Saunders had to say? Well, before we move on to the proposed changes to SIA, Professor Lucas, anything to add in terms of the fisheries?
I have a couple of very specific items. I had been looking in research that I've been doing at the compliance and enforcement provisions of the Fisheries Act, and there is a blog post up on the faculty's A-blog. And by the way, is everybody familiar with A-blog? Okay, that's the University of Calgary Faculty of Law blog. It's ABLAWG. Okay, so it's comments on case law, statutes, and other sort of legal issues. But a great deal of the posts, a great number of the posts recently have concerned the Fisheries Act amendments, as well as Bill C-69, the one that deals with the new impact assessment legislation and the new energy regulator legislation. So there were two things about the Fisheries Act that I had hoped that the amendments would address. Okay. The first one, Martin has already alluded to. I have thought it was odd that while all of these administrative monetary penalty changes had been going on in the federal government in relation to other legislation for quite a long time, there was nothing in the Fisheries Act of that nature. And in fact, there seems to be some kind of stubborn fascination with the idea of prosecution when you look at the Fisheries Act. That's a little bit hard to explain, especially as Martin pointed out, in situations that are relatively minor as opposed to the really large damaging situations. So I was disappointed in that regard. The second thing is Section 38 of the Fisheries Act deals with compliance and enforcement. And in the existing Fisheries Act, Section 38.3 talks about compliance. And it says that an inspector, for a purpose related to verifying compliance with this act, may enter any place or premises, etc., other than a private dwelling place, right, for which a warrant would be required because that engages charter protections. In which the inspector believes on reasonable grounds that A, there is anything that is detrimental to fish habitat. Okay, it's the believes on reasonable grounds part that I was looking at. And there is case law, there's Supreme Court of Canada case law that has addressed this question of the distinction between compliance activities and investigation activities. And the idea is that compliance activities are a sort of checkup kind of function to ensure, in the case of ongoing operations, it might be it might be mines or manufacturing operations or the like, that the standards are being met, that there is compliance. Okay, investigation kicks in when there has been an occurrence, when there has been an event that for which there are reasonable grounds to believe has resulted in an infringement of the Fisheries Act, and particularly the Section 36.3 provision concerning deposit of deleterious substances in waters frequented by fish. So the Supreme Court of Canada cases that I mentioned confirm that when the situation is compliance assurance is the term that's often used, you don't need reasonable grounds. You don't need reasonable and probable grounds. It's only when the activity turns toward the gathering of evidence for the purpose of laying a charge under 36.3, for example. It's only at that point that reasonable and probable grounds are required. And there are a couple of cases. There's a case called Jarvis from 2002 where the Supreme Court said, well, you have to look at this as a process in some cases, and the court talked about crossing the Rubicon, right, between compliance and investigation. So my point here is that as long as you have this reasonable grounds provision in relation to compliance assurance in 38.3, DFO is going to be gun shy, right? And is going to say, and there is evidence that this is the case, that, well, we need reasonable and probable grounds before we can do much about compliance assurance. And compliance assurance can include going in and taking samples, drilling test holes and the like. And in principle, it could even include directing companies to actually carry out monitoring activities, for example, and supply that information. So it's a little bit of a catch-22 where you need reasonable and probable grounds to do that, but you're doing that because you want to establish reasonable and probable grounds if you need to proceed toward actual charges under the Fisheries Act. So I had hoped that the reasonable and probable grounds in Section 38.3 would disappear, right? So that it would be easier to carry out these compliance activities, gathering the information that can, at certain points, depending on the circumstances, lead to investigations that go toward the laying of charges. But that didn't happen, okay? So I was disappointed.
Thank you, Professor Lucas. Before we move on to the proposed changes to SIA, are there any questions? All right, Professor Alinsky, let's take it away.
So I just want to thank Professor Lucas for talking about Jarvis and crossing the Rubicon. Our bona fides are totally established now as a proper environmental law symposium. It's just a case, and I'm hoping that some of my former colleagues at DFO are watching, because there's nothing more that they like to do than to spend time at a conference talking about Jarvis and trying to figure out what exactly it means. So I think that that's great, and I think the point is a good one, an important one. Moving on to impact assessment. This will be a shorter, quicker overview. And so I just wanted to essentially, and as Professor Lucas mentioned, we do have this ABLOG. We do use it a fair amount. It's a way for us to get our sort of analysis and discussions out on a quicker basis than peer review articles. And so everything that I'm talking about today, I've more or less written, and on the last slide, I have a link to the blog post. So turning to the Impact Assessment Act, or as it's going to be called, right? So that's maybe the first sort of obvious change that we're going to see, is that we're moving away from a regime that is focused first and foremost on environmental effects, and now we are going to look at a cross-cut of impacts, so not just environmental, but also social, health, and economic, actually. And so the idea is that we will now be assessing projects with a view to all of these areas, and not just their adverse effects, but their effects generally. So they're both their salutarious ones, but also their adverse ones. And that all of this information then goes through the decision-making process at the end, where the government will make a decision in the public interest about whether or not it thinks that these projects should go ahead or not. In terms of the actual mechanics, some of the big changes from the current SIA 2012, and again, all of this has to be sort of put into the context that there was a regime that existed from about 1995 until 2012, and then that regime, essentially SIA 92, a broad environmental assessment legislation that really focused on government decision-making as the trigger. So the point was, it wasn't so much about specific projects, it was more about when government makes decisions with respect to projects, then it has to consider the environmental effects of those decisions. That was a very broad-based sort of approach. It involved anywhere around 3,000 to 4,000 environmental assessments in a given year. When 2012 came around and the omnibus budget bills were introduced and SIA 2012 was introduced, we went down to about 50 environmental assessments. And so that decision-making trigger was essentially booted, and what was left was essentially a project list. And so when we talk about SIA, about this new Impact Assessment Act, I think, again, as a shorthand for those of us who are familiar with the current regime and familiar with the one that existed before that, we are talking essentially about a beefed-up version of SIA 2012. We are not returning to the pre-SIA 2012 days of a broad federal decision-making sort of assessment regime, but rather we are taking the current project list focused regime and just giving it some more muscle, giving it some more transparency, and maybe expanding it in certain parts. I think there are some parts where we are going to see a little bit, we are going to make up that delta of those lost 2,000 or so projects. But it is fundamentally structured like the current SIA 2012. Some of the bigger changes, under 2012, there were 3 potential federal agencies that would do EA. It was either the agency itself, the Canadian Environmental Assessment Agency, or it was, with respect to pipelines, the National Energy Board, and with respect to nuclear facilities, the Canadian Nuclear Safety Commission. And so each of those agencies could do their own environmental assessment for a project, sort of without having to engage any other party. That is no longer the case, or that will no longer be the case under the Impact Assessment Act. Under the Impact Assessment Act, either the agency is doing the EA in the case of a standard project impact assessment, or else it's going to go to a panel review. And that is going to be the case where the National Energy Board, or what will soon be called the Canadian Energy Regulator, and the CNSC, when they are going to be involved, when it's projects that fall within their wheelhouse, then they will participate in the EAs, no longer as sole authorities over them, but rather as members of a panel with a member from the impact assessment, from a roster essentially designated by the Minister of Environment. And on that point, actually, I just want, to those who suggest that this is such a calamity, this is essentially the pre-2012 baseline. This is how things were for the longest time. And then it was only really with the 2012 changes that suddenly the NEB, for instance, had this sole authority over a project assessment. We are simply just going back to that pre-2012 baseline on that point. There's going to be a new planning phase. And so this is very interesting. If you pull up the jurisprudence on environmental assessment in Canada, going back to 1992, Old Man River, EA was always about two stages. There was an assessment phase and a decision-making phase. So now, however, there are going to be 3 phases: a planning phase, an assessment phase, and a decision-making stage. That's saying a lot, and there's maybe a bit of uncertainty and maybe ambiguity, but I think fundamentally this planning process is not that different than what we've seen in the past. There's always been some room for consultation, public involvement, public participation in these early decisions. And what they've essentially seemed to have done is they've taken the screening decision under SIA 2012 and expanded it to include more public participation. So under 2012, I mentioned it's a project list, but even if you're on the project list, that doesn't mean that you necessarily will have an EA. The agency had about 45 days. You would submit an initial description, and the agency had 45 days to go through that, and based on some factors listed in the Act, it would decide whether or not an EA was required. So essentially, that process has now been expanded into a 6-month process. And it will have opportunities for public engagement. So when that proponent files that initial project description, that will be posted. First Nations, public will be able to comment on that, provide feedback to the agency. The agency will then prepare a list of issues that it thinks are pertinent or important about this project, which will then also post, and to which the proponent must then respond. And the idea, I think, is that they will respond, and that this entire process, if the agency decides that an EA is ultimately required, an IA, then all of that work informs the assessment work that happens next. Importantly, there is a kill switch at this point. If there are concerns raised in this planning phase that signal clearly to the government that this is a bad idea, that this is in nobody's interest, or that this isn't going to fly, they may say at that point that the project is done and it will not move on to an assessment phase. And so I think in some respects that's something that, again, it was, this sort of law reform makes strange bedfellows. And so in fact, this proposal for an early sort of what was described as a political decision-making process on projects was actually brought forward by the Canadian Energy Pipeline Association. I don't know if the result is what they had in mind, but in any event, we are going to have this kind of ability for the government, for parties, stakeholders, to get a sense of a project and identify early on if there are any red flags, anything that really suggests that it's probably not in anyone's interest to spend the next 5 years or whatever it's going to be, not just in terms of the assessment, but the litigation that would follow it if there is really staunch opposition. There are additional factors to consider. So I mentioned earlier social, economic, health, but it's not just that. We also have references now under Section 22, which is essentially lists the things that have to be considered in environmental assessment. We're going to talk about climate change, and we're going to talk, the report has to consider the extent to which a project contributes to or hinders Canada's ability to meet its climate change obligations. There's a reference also to other international, actually environmental obligations generally, and I think actually there's a reason, if the word international doesn't precede them, I think the idea is that there may be domestic obligations that the government is also prepared to entertain in that context. We're going to ask whether the project contributes to sustainability. So this is a new thing. So, under SEIA 2012 and its predecessor, it was all about significant adverse effects. And the general idea, the way the whole thing was, is if a project isn't going to result in any significant adverse effects, it can have a whole bunch of effects that are just below that threshold. But as long as it doesn't have any significant adverse effects, we assume that it's in the public interest, and it just sort of went ahead. The idea here is, and this is certainly something that the government has heard over and over, is that that's not good enough. That will not take you down the road of sustainability. And so the idea now is that there's going to be a test of some kind that the department will have to, the agency or whoever it is, the panel, to ask themselves, does this project, not only does it not necessarily result in significant adverse effects, but rather does it contribute to sustainability? And sustainability is defined in the Act. It is not a verbatim reproduction of the sort of standard definition of sustainable development, but it comes pretty close. We can, there's room for debate there about whether it should be a holus bolus replication, I think, of that classic international law definition, and what happens by the fact that it's not. We'll have to see. On top of that, in addition to having these factors, again, and similar to the Fisheries Act, it's like, well, how do you know that the minister or the agency or the governor and council, how do we know that they decided them? Well, they actually have to provide reasons, and the Act now says very clearly that the reasons have to show that they considered certain factors. So the decision-making factors are not, it's not the full list, it's not the same as the Section 22 factors. There's a subset of factors that are part of the public interest, and they include the contribution to sustainability, they include impacts on Indigenous rights, they include whether or not the project will hinder or is consistent with our climate change commitment. So there is that subset, and that's in Section 63, I think. And so on that, the one thing I will say about that is, of course, we are doubling down then on this idea that at the end of the day, environmental law is just about a decision-making process. And that as long as we make our decision makers consider things, the decisions will be the right ones, or at least as good as they can be. So like its predecessor, and like most predecessors in the sort of Western world, there is no environmental bottom line in the legislation. There is no clear indication in the legislation that certain projects, that they have a certain kind of effect, that there's no ability to allow them to proceed, okay? And this was, again, a part of the debate for the past 2 years. Some groups have pushed very strongly to say that there should be very strict rules around what kind of projects can proceed and the trade-offs that are allowed, and that there should be some kind of clear benchmarks, objective benchmarks that say that these projects are not on. The government has so far decided that that's not the way it wants to go. One of the, I think, side effects is something that we have to all accept, is that this process requires constant vigilance on behalf of Canadians, and perhaps more accurately, and not everyone's maybe a fan of these groups, but it is our public interest environmental groups, whether it's David Suzuki or it's Eco-Justice or whatever. These are the groups who are scrutinizing these projects on a routine basis, and they're the ones who are going to bring cases forward on all our behalf. And so it really becomes, this system, for it to work, really depends on their vigilance and their resources and their ability to test the machine every once in a while. Because, of course, it's seldom the case that anyone will bring down a government because they don't, or that we as a democracy, right, will bring down a government on the basis of a project being assessed and that we don't agree with that one decision. It's not to say that environmental law can't inform electoral politics. I think it is the case that the 2015 campaign was fought and lost to some degree on the basis of the changes to our federal environmental regime. But it becomes hard to suggest that there can be democratic accountability for individual project decisions, right? So that's a little bit what's going on there, and just one of the things that we have to realize about doubling down on this environmental laws process. I mentioned earlier there's this focus on these designated project lists. There's always also been in SEIA 2012 this kind of informal EA regime applicable to federal lands and projects outside of Canada. And so this was a recognition that, well, when we are dealing with federal lands, the government should have some awareness of the environmental effects of its activities. And so under the 2012 version, though, it's really a throwaway. And we've done some research, and I'm just going to switch here for a second because I wasn't able to cut and paste. But, so under the 2012 version, essentially, there was just an obligation for federal authorities who had any kind of decision-making process with respect to federal lands to satisfy themselves that the project or whatever would not result in significant adverse effects. So they had to make that determination. And then the Act said that on an annual basis, you will report to the agency your list. And I should add that if a project was likely to result in significant adverse effects, then they still had to get that permission from the GIC to go forward with it. The problem was that this became essentially like a black box. There was no registry for these projects. There was no way of knowing. And in fact, when you looked at the reports that were submitted on an annual basis, each department would have like a paragraph that big, and it just said, in this year, we had no projects that were going to result in significant adverse effects. And you're like, well, so how can how is it that we got that? So what we did leading up into the expert panel is I filed an ATIP with Department of Fisheries and Oceans, with the Department of Transport, and with Parks Canada. And I said, could you give me a list of, do you have a list somewhere where you're tracking these projects? And this is the kind of thing that we got back. So we get pages and pages of this kind of thing, and it simply just says, so on the left-hand column, it's like harbors. So there's Campbell Harbor, there's Ladner Harbor, whatever. Then, sometimes it's just like throughout BC. And then the project was, their loading equipment or their wharf components or its security and signage, so there's just no way whatsoever to know what was going on here and how the department was even determining whether or not in any given instance what it was doing was going to result in significant adverse effects. So this has been changed, I'm happy to say, in 2012, in the Impact Assessment Act. In that now for each of these decisions, every time these federal authorities make these decisions, they have to post them on the registry. And in some cases, depending on their discretion, they have to allow for public consultation. So that at least will allow on a real-time basis, and this was especially a problem with Parks Canada, and I should say, backing up, so I got that nice list from Fisheries and Oceans, and I got a list from the CNPCA, or from National Parks. Again, we're talking about hundreds of projects. I have yet to receive a list from Transport Canada, and that's been about a year. I think they've totally just forgotten about it. So anyway, so now they will have to publish those decisions on a regular basis, and there will be some opportunity. However, recognizing that at the end of the day, this can involve, and I remember this happened, at the time this discussion about this federal lands provision, when you change a light bulb, or if you're, doing any kind of work on a building, there was concern that that would trigger this obligation. So there's now provisions in the Act to exempt certain classes of works that are not likely to result ever in any kind of significant environmental harm. So again, giving and taking away. On the one hand, there will be much more transparency around these bigger projects, and we'll be able to have a sense of what's going on in a real-time basis and an opportunity for public consultation. But the minister has given herself the power to regulate, to exempt essentially certain classes of activities. I have, on a first initial reaction, it seems like that's a very scary kind of power, but then I think it is sort of pragmatically speaking, you have to have that ability, I think, to sort of set certain projects aside. So we'll have to see how that plays out. That'll be something to work at. So then the last thing that I think that I've spent some time thinking about, and that I think that there is lots of room for improvement actually though, is science and impact assessment. And so the government has certainly said that it wants better science. In our recent budget, we see that there is a lot of money going towards science in Canada, and they are looking to rebuild the scientific capacity of our departments as well. But the Act doesn't actually say very much about that. And so that to the extent that you want this legislation to constrain not just current governments that want to do a good job, but maybe future ones who are less inclined to do so, there's a lot that can be done on the registry, on the legislative side with respect to the registry. And so one obvious thing is to make sure, so on the registry, there's two files. There's two, for each project, there's an internal project file that the agency has that contains all records in relation to that project. And then there's the public-facing online project file. And so one of the things that several people are advocating for, myself included, is that these should be as similar as possible. There really is no reason to not ensure that raw data and proponent records are not publicly posted and subject to public scrutiny, rather than having to go through an ATIP process or anything else to get your hands at them. There's also just not really anything about the role of science in decision making. And so I think that there's with respect to mitigation measures, one of the big problems we have under the current regime is it seems like you can propose almost any mitigation measure, and there's no test in terms of saying like of demonstrable effectiveness, or for science to at least support effectiveness. And so I think that there's some room to sort of insist that when proponents rely on mitigation measures or propose them, and the government's prepared to rely on those, that they be demonstrably effective, or at least support that their effectiveness is supported by the best available science. So there's room for that. There's rooms around, I think, in the preamble, at least in the purpose, to speak about the value of scientific integrity, and have that just drive the machinery a little bit more. So I think that's where I would leave that, and then we can take questions or